Thank you, Hannah. We are very excited to have Tia back, the owner of Rental Housing Support Services. She's a rental owner herself, as well as a licensed property manager. She's president of the Oregon Rental Association and president of the Rental Owners Association for Lane County. I'm going to go ahead and turn it over to Tia because, as Hannah had mentioned, she's got lots of information, so we're going to launch right into it. All yours, Tia.
Thanks, Amy, and thanks everyone for inviting me to teach. I really appreciate it. Let me get my screen. I do want to correct one thing, is I am not a licensed property manager anymore. I used to be, but now I'm not. Now I don't know which one to choose, but let's try this one. I just want to make sure. So can you guys see me and can you see the PowerPoint? Are you seeing what you saw before, or is this working?
Looks perfect. Yeah.
Fantastic. All right. So as the intro folks said, we're going to save questions till the end. So write those down and we'll get going. I do have a lot of information to share today. I do wear a lot of hats in the housing industry, but what I am definitely not is an attorney. I'm not giving you legal advice today. You should always consult a competent attorney for advice related to your specific situation. And yes, I put the word competent in there for a reason. Just like every walk of life, there are people who are better at their jobs and some who are worse at their jobs. And when you need an attorney, it is not the time to go bargain basement shopping. You need the best attorney money can buy. I also like to point out that the class and the laws I'm referencing in this class are current to the date of publication. As we saw during COVID and as we see during every legislative session, it seems like they've got it in for landlords and things are just changing every single year. So this applies to today. Tomorrow might be different. So let's get started. We're here to discuss overcoming barriers to selling a tenant-occupied property. And one of the first things I want you to try to do is to get the renter's cooperation if you can. Some will be, some won't be. Nobody's going to be happy about it. And so I want you to start with a plan that might look like something like this. You know, offer to sell the unit to the renter, right? It rarely is successful, but it's not unheard of either. I've brokered a few of those transactions in my career. And when that happens, it's always a great thing. It makes it an easy task for everyone. Also, you know, if it isn't successful, you need to be aware that renters are not going to be happy about this, right? This is not good news for them. And so try to understand that this is an upsetting thing. Imagine what it's like for you to have to look at likely having to move. It's not something, unless you were planning to move and you were doing it on purpose, that you're going to be happy about. So just be aware of that. They also may have a sticker shock or find a lack of available units out there if they're in a unit that's been under the market price. During COVID, a lot of people were using that as an excuse not to allow entry. We're not seeing that quite as much, but we're still seeing it. Oh, I'm sick. Nope, can't come in. One guy had MRSA, and he actually did have MRSA, but they were like, you can't come in for 60 days. And then they, you know, we talked to the doctor and they were like, no, a week is good, right? So, you know, tenants will find various and sundry ways to try to obstruct you. And that's what I want you to try to overcome. One of the things that can help reassure them is your commitment to reducing the number of showings by having the realtor first enter to take a video and photographs, right? So have the place looking good. You might consider paying for part of that to have the home and yard spruced up. Even if those things are the renter's responsibility, you might want to talk to your client about that. You know, shelling out a few $100 just to get that good curb appeal going and have the place looking as good as it can be a real a benefit to you. Then what I want you to do is consider having any interested party prior to scheduling a showing, view the video and the photographs and do a drive-by. Do they like the neighborhood? You know, as a property manager, I many times leased up people who never saw a property and they showed up and it was like, well, I didn't know it was next to a Quickie Mart, or, oh, this is in the wrong school district, right? So, you know, I think there's ways that you can reduce the number of showings, and those are a few of them. You require interested parties to view the video and the photographs and do a drive-by. And then you might even require some amount of pre-qualification prior to you actually doing an in-person showing. I'm sure you all have experienced this, where you got looky-loos. You know, oh, I've always wanted to see the neighbor's house, right? And so, you know, try to limit your showings to serious buyers only. when you're discussing the plan with the renter, try to have them pick 2 or 3 days per week, 1 or 2 weekdays and 1 weekend day, and do your best to limit in-person showings to those 2 or 3 days whenever possible. At least they understand then that, hey, 4 to 5 days a week, I'm going to be left alone to live my life. And I think that's reassuring as well. Like, okay, we'll let you, schedule showings for Wednesdays and Saturdays, right? Or whatever other days work for them. I think it's also important to communicate to the renter the timeline for termination so they know they have time to plan their move. If the renters are willing, you may enter into an agreement for property showing. We've got a form called entrance agreement for property showing. That's ORA form 013. Few renters are going to be willing to sign allowing entry without notice, but it doesn't hurt to ask. Honestly, the only people I was ever able to get to agree to that were college students, right, who weren't planning to be there anyway. So we have a form available if you can convince them to do that. The statute says a landlord and tenant may agree that the landlord or the landlord's agent may enter the dwelling unit and the premises without notice at reasonable times for the purpose of showing the premises to a prospective buyer, provided that the agreement is executed at a time when the landlord is actively engaged in attempts to sell the premises, is reflected in a writing separate from the rental agreement and signed by both parties, and is supported by separate consideration recited in the agreement. So we'll talk about consideration in just a minute. The statute says a landlord or the landlord's agent has the right of entry after providing a minimum of 24 hours notice. And so a lot of folks will slap that notice on the door and then be grumpy when they show up and the tenant won't let them enter. But there's 2 types of denials of entry. There's reasonable denials of entry and unreasonable denials of entry. A reasonable denial of entry is when you just, without thinking about what's going on in the tenant's life, just say, we're coming in at this time. And the statute says they can issue a reasonable denial of entry if the date and time of entry conflicts with their reasonable and specific plans to use the property at that time. So I used to have tenants who had an infant and 2 toddlers, and 1 to 3 p.m. every day was no, you can't do anything here during those hours, right? Because that was nap time. What if you want to show a property on a Saturday and most of the time they've agreed to that, they've agreed that that's probably the best weekend day, but the time you want to enter, they're planning to have their kid's birthday party. Those are reasonable and specific plans. So under a situation like that, the tenant can issue a reasonable denial of entry and you need to reschedule. But an unreasonable denial of entry is when they're like, you're never coming in here, right? And they won't cooperate in any way or agree to anything. While a landlord may not abuse the right of access or use it to harass the tenant, a tenant may not unreasonably withhold consent from the landlord to enter. For unreasonable denial of entry, you can serve a notice of termination with cause. We call this a 3014. Some people call it a 1430. We're talking about the same thing. It's a 30-day notice of termination with a 14-day right to cure. The notice provides the renter with a minimum 14-day cure period to allow entry, or their tenancy would terminate in a minimum of 30 days. That seems like a long time to wait. I know, 2 weeks, right? But if the tenant unreasonably denies entry again within 6 months, so this notice, if they cure it, puts them on what I call double secret probation for 6 months. So if they unreasonably deny entry again within 6 months after serving that 3014, the same statute allows a landlord to serve what's called a repeat violation termination notice and terminate the tenancy with 10 days written notice. The renter has no right to cure and may be evicted if they don't move out. The denial must be unreasonable. You may have to prove that both the original denial of entry and the repeat denial were unreasonable and that your notices are perfect in every way. That's why it's helpful to start with a plan, so you have something to show a judge in the event you or your seller end up in eviction court. Communications with the realtor or with the renter, excuse me, showing the efforts made to address their concerns and your attempts to be flexible and adapt to their schedule should be helpful in proving their specific denial was unreasonable. I do recommend at least 2 attempts at entry prior to serving that for-cause notice. And I recommend noting on the 24-hour notice to enter that the renter should contact you for an alternative time if yours is not okay. You might write up something like this. We will only spend as little time in the unit as possible and expect the walkthrough will take a maximum of 15 minutes. If the listed time and date for entry conflicts with your specific plans to use the property at that time, we will accommodate a different time or day within a 48-hour period following our intended date and time for entry. Otherwise, please be advised that your tenancy may be terminated as allowed by law for unreasonable denial of entry. under ORS 90.322. Education is part of our job, and the way we educate is by showing people the statutes. Many tenants will want to be present during showings and may become obstructive for that reason. Some tenants will make showings a nightmare by following you around and bad-mouthing the property while it's being shown. Money makes everything better, but not always. I said we would talk about consideration, and for some reason, I seem to be missing that slide deck. So one of the things that I always negotiated when I was a property manager and one of my owners wanted to sell their home was consideration for each showing. That's money, right? So at that time, I was negotiating $10 to $20 per showing, and maybe, $20 an hour for a 4-hour open house if we're asking them to be gone for that long. I think that's part of what you're going to do to help convince the tenant that this isn't as bad as they might think, or that you're giving something in order to get something. Think about how it would be for you to have strangers tromping around your home and then not to be even offered anything for the inconvenience. I think that's a mistake. I think most realtors are aware of that, but I always had a few who were, and a few owners who were like, it's my property, I can enter when I want. And it's like, yeah, you can. But you'll catch more flies with honey, and it's just a little bit of money. So go ahead and see whether that can help. Document all attempts to interfere with the process in case the landlord and tenant end up in court. So let's talk about how you terminate tenancy. It's going to be easy if it's during the first year and you're not in Eugene or Portland or Milwaukee. In a month-to-month tenancy, where occupancy is still within its first year, you are allowed to serve a no-cause notice at any time, and we have a form for that. A fixed-term lease can be terminated at its end, but only if the specified ending date of the fixed term falls within the first year of occupancy, right? So if you have a lease of more than a year, there is no no-cause option, and we'll talk about what the other options are in a minute. The notice may not expire prior to the lease expiring, but may overlap the lease end. So if your client wants to put the property on the market now, and the lease isn't expiring until June 30th, but there was a start date and the tenants moved in on July 1st, right? The specified ending date is falling within the first year of occupancy, and the landlord could serve a notice of non-renewal of lease. If you were serving it now, it would be more than 30 days, right? But let's say that they come to you in the middle of June with that lease set to expire then they can still serve that 30-day notice of non-renewal of lease. That the termination date is going to overlap the end of the lease, but that's okay, as long as it's effectively served prior to the lease expiring. In Eugene, Milwaukee, and Portland, a notice of termination without cause requires a 90-day notice period, even within the first year. And in Eugene and Portland, there are special forms that must be included and may require payment of relocation fees unless the landlord is exempt. You need to seek legal advice. After the first year, the landlord may only terminate tenancy for cause, which are tenant violations of the lease or landlord-tenant law, or for one of 4 qualifying landlord reasons, with a minimum 90-day written notice. Those reasons are the property is being demolished or converted to a different use within a reasonable time. The landlord intends to undertake repairs or renovations to the property within a reasonable time, and the property is unsafe or unfit for occupancy or will be unsafe or unfit for occupancy during repairs or renovations. The landlord intends for the landlord or a member of the landlord's immediate family to occupy the dwelling unit as a primary residence, and the landlord does not own a comparable unit in the same building that is available for occupancy. Or 4, the landlord has accepted an offer within the past 120 days from a buyer who intends in good faith to occupy the dwelling unit as their primary residence. Each of those 4 options requires a minimum 90-day written notice, and in a fixed-term lease, the notice may not expire prior to the lease end. So you serve, you get an offer in mid-June, but that lease doesn't expire until the end of October. Well, you're not going to be able to terminate tenancy any sooner than the end of October. Options 2 and 4 are what sellers and realtors are typically using, but there are issues either way. Some sellers don't want to be the bad guy and serve the notice. Like a lot of our older landlords are getting terrified by all the changes, and they've kept their rents really low and they love their tenants and they feel really bad they have to do this, but they're out. And they're like, no, I don't want to do that, right? Because they care for the people that they've been renting to and don't want them mad at them, I guess. Most buyers are going to need the seller to serve the notice so that they can get owner-occupied financing. For sellers and realtors, talk to your clients about this and decide ahead of time what you're going to be willing to do. Also remember, a lease supersedes a sale. Except when terminating for cause, a notice of termination cannot expire prior to that lease end. The notice of termination must be prepared and served perfectly and will remain in effect for the buyer. So if the seller is willing to do that notice on behalf of the buyer who's going to occupy, then the notice can transition to the buyer if the property closes, prior to the notice expiring. Even with an all-cash sale, though, the buyer could end up purchasing a huge liability if the seller failed to prepare and serve the notice in accordance with the law. Hire an attorney or an eviction specialist to assist you. Because messing up a notice is the biggest way that tenants win in court and that landlords lose. One mistake and you're toast. If the renter doesn't move out, a court action is the only way to force them out. We're not seeing a lot of tenants challenging these notices, but it could happen, and we are seeing it, just not, overwhelming numbers. So make sure all parties are aware of the worst case scenario. And even then, the tenant has the right of due process and can challenge that notice in court. If the buyer proceeds to eviction court and they have inherited a defective or imperfectly served notice of termination, they could lose the case, maybe have a judgment rendered against them, possibly have to pay the tenant's attorney and start all over again. Who's going to get sued if that happens? Everyone. So get qualified legal advice. And I'll tell you what, it's getting better, but I can't believe how many realtors who are unqualified to give advice give legal advice. So stop it. Don't do that. You can get in trouble for that. For buyers, if the seller won't serve the notice, then the buyer can do it after closing for the qualifying landlord reason that they are a member of their immediate family, need to occupy the unit as their primary residence. That can pose issues with financing and interest rate, which is why buyers want the sellers to do it. For sellers, you got a few choices. Sell the property with the renter in place and wait for an offer from a buyer who intends to occupy, then serve the renter that 90-day notice. Give the renter a 90-day notice for renovation, remove the renter, renovate the unit, then put the property on the market. I'm sure that's what all realtors would like to have their clients do, but maybe your clients can't afford to do the renovations that would make the property sell better. So we'll see. Or 3, sell the property with the renter in place and make it the buyer's problem. But talk to your seller ahead of time so that you're not, setting people up for disappointment. If, they go, yay, the buyer's agent comes, we've got this person who wants to live there. And then they discover that the landlord's unwilling to serve the notice. So it really depends on what the seller is willing and able to do, which option would be preferable. If the property is in poor enough condition or will pose a hazard to health and safety during renovations, this might be the best choice if the seller can afford those renovations. We have no case law on what constitutes unsafe or unfit, so you should always err on the side of caution. If you're choosing the renovation option or your seller is, some examples of what would most certainly qualify: hazardous materials being disrupted, asbestos in flooring or popcorn ceiling texture, that's a good one. Lead-based paint, if you're going to be disturbing substantial quantities of that. Tearing out the only bathroom or kitchen, repairing substantial rot, removing walls, rewiring or repiping or other substantial electrical or plumbing, foundation repairs that require floors to be cut out. Superficial renovation like paint and flooring may not qualify. Windows and doors can be replaced from the outside, but if there's structural rot or lead-based paint, might qualify, right? If you've got to do some repairs to the actual structure. Hot water heaters can be replaced in a matter of hours. Plumbing main lines can be replaced in a day or two. Kitchen counters can be replaced in a day or two. I've had realtors try to stump the chump and what about this? What about that? And I want y'all to be honest. A lot of you are probably rental owners as well as realtors. We've done a lot of work in place when we have a tenant we want to keep, right? As long as it's not endangering their health or safety, be honest about it, because if you get challenged, you could lose and it could be a problem. I want to make you aware of what I call the duplex rule. There's an exception in termination law for a property where there's 2 units on the same tax lot and 1 unit is the landlord's primary residence. In this situation, it allows termination of tenancy for no cause with a 60-day notice, even after the first year. It's kind of the old rules we used to be under before Senate Bill 608 passed. For a property sale, however, the landlord can issue a 30-day notice of termination under specific circumstances. So remember, it's a maximum of 2 units on the same tax lot. 3 or more, you can't do this. The landlord must occupy one as their primary residence. The buyer must intend in good faith to occupy the tenant's unit as their primary residence. If instead the buyer wants to occupy the owner's unit, then the tenant comes with the sale. We have a form for that. Remember, in Eugene, Milwaukee, and Portland, you've got additional requirements and timelines. It's driving me crazy, all of these city things that are coming up. It's so hard to keep track of what, what the overlays are in each jurisdiction. If the duplex is an investment property but not owner occupied, the same rules would apply as though you were selling a single family home. For a tenancy of more than a year, a seller can issue a 90-day notice for the buyer to occupy one or both units, or sell the property as is, and the buyer can issue the notice. Once the notice expires, the tenant vacates, the buyer can then move in. The renovation option is also on the table. So how is the seller supposed to know if the buyer is going to want to keep the property as an investment and be willing to take on the existing tenancy, or if they want to purchase the home to occupy as their primary residence? Well, you won't until you get an offer. But single family homes generally sell to first-time home buyers. And I don't know about you, but my realtor friends are telling me since COVID hit especially, we're seeing a huge increase in buyers of duplexes who want to occupy one or both sides. So it can be a benefit to have at least one side vacant. I think families are wanting to sort of circle the wagons, live closer together to help each other. COVID changed a lot about our society, and I think that's one of the ways it's changed. Most buyers are going to need a mortgage to purchase a property. Most rentals sell to first-time home buyers, right? And that interest rate lock can expire as early as 45 days. The buyer may be required to occupy the home within 30 to 45 days after closing. It creates another layer of complexity, which is why sellers may want to terminate tenancy ahead of time if they can. There can be issues if the buyer won't be moving in, but is buying the property for a family member to occupy instead. So the only notice a seller can serve, and I've had some confusion with realtors over this, is for a buyer who intends in good faith to occupy the unit as their primary residence. So if the buyer doesn't intend to live there but wants to buy it for a family member, then they've got to wait until they own the property to serve notice for a family member to occupy, unless a family member is on title. If purchasing a duplex with the buyer intending to occupy one side and have a family member occupy the other side, both the parties must be on title, or the buyer has to wait to issue the notice until after closing the sale. So if you have a duplex you're selling, one side's vacant, the buyer, wants to occupy that as their primary residence and maybe wants their daughter or sister to occupy the other one, well, there's no notice the buyer or the seller can serve to make that happen, except for the one side that the buyer wants to occupy. And then once they live there as their primary residence, then they can issue that 60-day notice to the other folks on the other side. If you're terminating a tenancy for a qualifying landlord reason, we've got a form for that. We're going to focus on the two reasons that impact property sales, right? The landlord intends to undertake repairs or renovations to the unit, and the unit will be unsafe or unfit for occupancy during renovations. Or the landlord is selling the unit separately from any other unit and has accepted an offer from a buyer who intends in good faith to occupy the unit as their primary residence. A lot of people still are confused, but you can't serve a 90-day notice just because you want to offer the property for sale, right? You have to have an accepted offer. And if the sale falls through, which has happened, the landlord must rescind the notice and start all over again once a new offer is accepted. So I've served several of these notices. I've had some fall through, and then we had to serve a new notice as soon as we got another accepted offer. In a termination for a QLR, the landlord must provide supporting facts. This is one of the biggest defects I see in these types of notices. We don't yet know how detailed these facts need to be, so better too much description than not enough. It might be helpful if you're renovating, right, to have a contractor's bid state that the unit will be unsafe or unfit for occupancy during renovation and provide a copy of that with the notice. Otherwise, if the owner will be renovating themselves, they need to explain why the unit will be unsafe or unfit. What exactly are they going to do? Again, if there's lead-based paint or asbestos-containing materials in the home, that can bolster the case for it being unsafe to occupy. I've done 2 of these notices. One was a property we sold in 2021, and we had to dig a new well, which we'd already done, but then we had to move the pressure tank, dig all new water lines because the old well was going bad. So that was major. Like that alone probably would have done it. But we were also tearing out some walls. We were doing some bathroom and kitchen renovation, although not complete, like we weren't tearing everything out, just partial. Did a whole bunch of cosmetic work as well and some electrical. But what was really going to render it unsafe or unfit was no water. You can't have a habitable unit without water. And also the tearing out of walls, it was a 1933 unit. And we said, the unit was built circa 1933 and might contain lead-based paint or asbestos, posing a hazard to health and safety during renovations. Some notices I've seen just declare that the owner is undertaking renovation that will render the unit unsafe or unfit without describing what they're going to do. It's not good enough. I even saw an attorney do one of these once. I'm just like, that notice, I don't know. A lot of tenants won't know that the notice is defective and may just move out anyway. But if you're challenged, I'm seeing a lot more tenants going and getting legal advice. We also have a circuit court ruling out of Salem. The landlord must describe the intended renovations. And a landlord lost in a Salem circuit court based on him just putting the statement in there, I intend to undertake repairs or renovations that will render the unit unsafe or unfit to occupy. For a property sale to an owner-occupier, the landlord must provide written evidence of the accepted offer. So include a copy of the sales agreement indicating the buyer will live in the unit. It's okay to redact private info. I have realtors freak out about that. Oh my God, they're going to see the names. Oh my God, they're going to know the sales price. It's like, it's public record anyway, but okay, if you're concerned about that, black it out in Adobe, right? Well, whatever. I've done a bunch of these, and in some sales agreements, it does indicate the buyer will occupy, and in others, it doesn't. So if it doesn't, what I want you to do is have your buyer's agent, or if you are the buyer's agent, execute an addendum or an affidavit indicating that and include it with the sales agreement, right? So just say, buyers intend in good faith to occupy the dwelling unit as their primary residence after closing. I'm kind of a risk freak. If you've taken classes from me before, you know that. And so I just want you to be as safe as possible. The landlord must provide the notice and evidence of the sale at the same time and within 120 days of the offer. And I always wondered, why would it take 120 days? That's a really long time. But then I learned why. I had one of my clients that I do evictions for served a defective 90-day notice, took it to court, lost, had to pay the attorney. Then they served another defective 90-day notice and asked me to file on it. And I looked at it and said, your notice is bad. And they're like, what? Your notice is defective. You didn't do what you were supposed to do. So by the time they hired me to serve the proper notice, 180 days had passed, right? So then before I was able to do that, we had to have the seller and buyer execute a new sales agreement. So that can happen. Our form doesn't give a lot of room to explain your supporting facts. So you can attach an addendum or a copy of the contractor's bid or sales agreement and indicate that on the supporting facts line. See attached addendum for supporting facts, right? So when I'm doing a renovation and I've got a long list of stuff to do, that's generally what I'm doing. But with a property sale to an owner-occ buyer, I put see attached sales agreement and buyer's affidavit on that supporting facts line, staple them together, and that's good enough. Your landlord might have to pay relocation expenses. If the landlord holds an ownership interest in more than 4 residential rental units, the statute says units subject to Chapter 90. So we know now that doesn't mean your vacation rentals. That doesn't mean your commercial rentals. It doesn't mean your own home, right? It just means your residential rental doors. If you have a 4-plex, that's 4 units, right? Then if you've got 5 or more and you're terminating for a qualifying landlord reason, the landlord must pay the tenant the equivalent of 1 month's periodic rent at the time the notice is delivered. Owners with 4 or fewer units are exempt from the state relocation fee. If not exempt, the payment must be made at the time the notice is served, or it will be considered a fatal defect in the notice. Eugene and Portland relocation fees are much higher and required to be paid even within the first year of occupancy and regardless of how many rental units are owned, with some exceptions that must be registered with those cities in advance. State fees are due at the time the notice is served. Both Portland and Eugene require, say that you can reduce the amount of the city fee by whatever you're paying under the state fee requirements. And those fees, so city fees are due within 45 days of serving the notice. So first fee has to go with the notice. The second fee can be sent within 45 days, or you can just provide all the fees with the notice if you wish. Have your clients get help so they don't mess it up. The state relocation payment must be included with the notice. And again, the city fee within 45 days of serving the notice, regardless of whether the tenant is current on rent or owes money for something else. They cannot be issued as a credit against future rent obligations either. Pay them or the notice is materially defective and unenforceable. Oh, we already talked about no cause. Sorry about that. I forgot to change my title here. There are other ways a landlord can terminate tenancy. For cause terminations are able potentially to be cured depending on the violation and can be complicated. My record for a for cause notice was 17 separate violations. Took me about 2.5 hours to write that notice up. Tenants took one look at it and said, we'll move out. And they did. Encourage your client to seek legal advice, as it may be possible to remove the renter ahead of the sale if they're violating the rental agreement or landlord-tenant law. You know, evictions are scary for people, but it's just a process. In subsidized, you have other considerations. In subsidized housing, the housing assistance payment contract, we call it a HAP contract, may specify a longer notification period, like 60 days, or require that a notice of termination without cause expire at the end of a calendar month. So you need to check that HAP contract, or whoever's doing the notice needs to look at that contract. It's really important that you be aware of whether you've got a subsidized tenancy, and if so, you need to see that contract. When you serve any notice to terminate the tenancy of a subsidized tenant, remember you're also required to send a copy to the agency providing the subsidy. You got to make sure they receive it. So what I always want to do is email it and get an acknowledgement email back. So here in Eugene, I email paperwork@homesforgood.org, you know, if it's a Homes for Good property, and I get an automatic reply saying, hey, we've received your thing, we'll be in touch, right? That's what you want. Don't trust the mail, don't trust a fax. If you need to, hand walk it in there and get a receipt that they received it. I've been 3 times during COVID, I had Homes for Good tell me they never received a notice. Thank goodness that I had emailed it and gotten that response email. We were able to send that to them and go, gee, you responded that you did get it. And they were like, oh, gee, I guess we did. Okay, we'll work with you. There is the first part of ORS 90.427 is a statute that everybody should be aware of. The first part out of that statute says first year of occupancy includes all periods during which any of the tenants has resided in the dwelling unit for 1 year or less. So what that means is if a new tenant gets added to the agreement, we're not talking about a kid aging in, not a temporary occupant or caregiver, not a guest, then you can terminate tenancy based on the first year rules. And there's still a lot of landlords who, for some reason, don't belong to a rental owners association and don't know that. So now you know it and you can advise them about that. You got to be aware of waiver. So many times when I talk to landlords, they have potentially or have definitely created waiver in one area or another. There's various ways to create waiver in tenancy, but when you're serving notice, you must track payments. Accepting rent beyond the date of termination in an active termination notice will create waiver. The notice will be invalid. To avoid creating waiver, a landlord has 10 days to return any overpayment by first-class mail or personal delivery. It doesn't mean you have to return the tenant's original payment, right? If you have a notice that's expiring in the middle of a month and they paid you a full month's rent, all you have to do is return the difference, right? So you can cash the check, the owner can then write their own check back to the tenant and they won't have created waiver. Other issues can happen after the notice is served. Many times after receiving one of those 90-day notices of termination, the tenants will stop paying rent or stop communicating. So the landlord may need to follow up with serving a notice for non-payment. On any move out, the landlord should send move out instructions. We have a form for that. And if they don't move out, the landlord will need to head to eviction court. Okay. Property management can be another problem in this process. If the tenant occupied property is being managed by a third party, it can create problems. Some managers are willing to serve notice, others aren't. Some managers have in their contract that they'll cancel management immediately if the property goes up for sale. What happens then? I think it's important for you to ask the owner to review their management agreement, or you review it to see what might happen, because they need to be prepared for potentially managing the property if that's going to happen. And the owner should address this with management ahead of time so they can plan a strategy. If the property is an investment property, you know, they're selling a, you know, fourplex or whatever, it might be a different story than if the manager is going to lose it from their inventory or their portfolio of properties. Delays in move out. This happens more than half the time due to either an obstructive renter. I can't find anything. And no matter how many times you tell them, look, by the time the sheriff comes, you're going to have figured it out. Why don't you move out now without an eviction instead of making us go through this horrible process? but they still do it. Maybe they've actually have been able to get a new unit, but it's not ready, right? When the notice, like to totally coincide with the expiration of the notice. Or they can't find anything. What's going to happen then? You guys need to be aware of this and talk to your clients about it. I want you to try to build in some ability to provide more time if the renter will put their notice in writing to you and pay for that extra time. Why do you want to do that? Well, a better chance of avoiding eviction court, especially if they do have something lined up, right? And they can show you that, right? They paid a deposit to hold somewhere and it's going to be a week longer than you wanted or 2 weeks longer. The real benefit to a tenant's notice to vacate is it's the easiest notice to win in eviction court. Unless you held the gun to a tenant's head and forced them to sign it, there's no defenses at all. And you may have less personal property to deal with. For these reasons, in most cases, I would include an offer of an extension if the tenant will give you notice. If you do negotiate that, make sure the notice has all the required elements, the names and signatures of all adult tenants, the property address, the date to vacate, and the date the notice is created and served. The deposit accounting, this is a huge issue. Who's going to turn the unit, reconcile the deposit, and send a refund or an invoice? Well, it's ideal if the seller does it. They're the ones with the history of the unit, right? A buyer with no experience and poor documentation of the condition on move-in may want to just refund. I tell people who are taking over a unit, if you don't have good documentation from the person you took it over from, the seller, go do an inspection, take pictures and kind of record the condition at that time. That way, at whatever point they move out, you've got something, okay, it was like this when we bought it. Now it's like this. So you must have done that damage. But whoever reconciles that deposit, if the tenant contests it, they're the ones who will be faced with a small claims suit if there's a disagreement. Insurance is another thing you need to be aware of. Homeowner insurance policies may not provide full coverage for a unit if it's vacant. Vacant home insurance can be 3 times as expensive as regular home insurance. When my husband and I were selling ours, we had to pay almost twice as much for vacant property insurance during the time after that first 30 days before we sold it. But typical homeowners insurance policies won't cover fire, vandalism, liability, or other types of claims on an unoccupied or vacant property after 30 to 60 days of it being vacant. So advise your owners about this, and individual policies vary wildly. So have them check with their insurance agent if the property is going to be vacant. Cash for keys is a tried and true method for regaining possession of a property, and there's absolutely nothing that prohibits both parties from making a mutual termination agreement. Why would an owner want to do this? Well, it avoids the uncertainty of the courtroom. You may spend $2,000 or $3,000 litigating, and you might lose and have to start over, right? It's uncertain, right? They may have created waiver. They might lose based on retaliation. There may be a defective notice. Money might need to be paid anyway. A release of claim allows the seller, the buyer, and the agent to be free of worry over lawsuits later. And that's what our form does. It not only is a mutual termination agreement, it releases everybody from any claims forevermore. And then there's a definite timeline for occupancy by the buyer. If an agreement is reached, you need to make sure that it is well written and enforceable. What are the parties' obligations? The money is to be paid in what form? Usually certified funds. By when exactly? What date and time? What happens if either party fails to keep their end of the bargain? If both parties comply, our form includes a release of all claim. If you do something else, it should include some sort of release related to the tenancy and the transaction. We have a great form, mutual termination agreement, release of all claims. You can use that form to spell out the terms. This is one of my finer efforts. I wrote it up, taking stuff off the internet here and there, threw it all together, sent it to the attorneys, and they were all like, wow, that's really good. Only one attorney said, I want you to add this one sentence. So it has been legally reviewed. If you're selling an actual investment property, termination laws don't impact property sales where the seller and buyer are both investors and the buyer won't be living at the property. But there are still issues that can make the property easier or more challenging to market. And I probably don't need to tell you all of this, but I'm gonna anyway. The price of rents, right? Market rents are going to make the property more attractive to a buyer. The quality of the tenancies, right? tenants who are keeping to their lease are a fantastic marketing asset. Completeness of the seller's documentation. This is the biggest one I see, where sellers have been kind of lazy landlords. They haven't inspected. They use funky free forms off the internet. I remember once one of my clients bought a fourplex, and I had three agreements where I only had the first page, and then the other one I had 2 pages, right? And that was all they could get. And it was a real nightmare for us and for the owner, because we had no documentation of the condition. We had nothing. And so that was a problem. Market rate rents garner market rate sales prices. Cooperative residents who are keeping to their lease and caring for the property are a fantastic marketing asset. Problem residents are not. The completeness of the seller's tenancy documents can also help or hurt that sale. So if there are gaps or flaws in your seller's paperwork, try to get them to fix those now before marketing the property for sale. What does good paperwork look like? Well, the rental agreement and all addenda are complete, initialed, signed, and dated by all adult occupants. The seller has good documentation of the condition of the units on move-in, photos, videos, written reports. There are accurate tenant ledgers and good notes and copies of notices regarding lease violations during the tenancy. Without good paperwork, a buyer may be purchasing liability. And so if you're a buyer's agent, listen up. For example, the seller's marketing their property built prior to 1978, but has no signed lead-based paint disclosures with any of the tenants. The penalty for this violation, if reported to the EPA, is $6,000 per violation. So the buyer could require, as part of the sale, that the seller fixes the deficiency in the paperwork so they're not taking on that kind of liability. You, as a seller's agent, should be talking to your buyers about that and going, look, you need this. Otherwise, we're going to have a harder time selling the property. Or a buyer could agree to accept responsibility for fixing the problem after the sale, but use that deficiency to negotiate a lower price. Buyers should request copies of all leases, addenda, and tenant ledgers and review them for completeness, or have an attorney or professional consultant review them to make sure there's no illegal provisions, or if there are, so you can't enforce those. I tell you, landlords can be what I call pathologically frugal sometimes. They cheap out on forms. Oh, look, I got this free thing off the internet. I'm going to use that instead of spending $7.99 for a proper rental agreement, right? That's a lot of money. And it just baffles me, because it really hurts them in the end. Also, any existing notices of termination should be reviewed by an attorney or professional consultant to ensure that they will hold up in court if the buyer purchases a property before that notice of termination expires. I once had a lady call me, and I guided her through, and this was actually a management company who had issued a defective notice. And she had already bought the property. She's like, oh my God, what do I do? And I'm like, all I can recommend you do is go talk to the tenants. They don't know that the notice is defective. Go talk to them and see, talk to them about, hey, you give them more time if they'll put their notice in writing to you. And it worked. So the defective notice ended up not being a huge issue, but it could have been. It could have been. It is essential that both parties ensure that any notices of termination are prepared and served perfectly. It seems so easy, but I'll tell you what, as an eviction specialist, I see it messed up all the time. They check the wrong box. They put a date where a time should be, or a date where a time where a date should be, or they serve it illegally. There's so much to know about it. It's not as easy as it looks. A defective notice of termination can result in a loss in court. For sellers, that can mean a lost sale. For buyers, it can mean a long delay in being able to occupy the property. And for both, it can mean a court judgment against them, payment of attorney's fees to the prevailing tenant, and starting all over again, which is really going to piss off your buyer. So the takeaway for today's class, whether you're a buyer's or seller's agent, you owe specific affirmative duties to your clients, in part to deal honestly and in good faith, to present all written offers, written notices, and other written communications to and from the parties in a timely manner, to disclose material facts known by the agent and not apparent or readily ascertainable to a party, to exercise reasonable care and diligence. You've got this information now. You need to encourage your people to seek legal advice if they need it. To account in a timely manner for money and property received from or on behalf of the buyer. To be loyal to the client by not taking action that is adverse or detrimental to the client's interest in a transaction. To disclose in a timely manner to the client any conflict of interest, existing or contemplated, to advise the client to seek expert advice on matters related to the transaction that are beyond the agent's expertise. During COVID, I got a call from a landlord who said, hey, I just wanted to run by what I just did with you to see if I messed anything up. She had a fixed term lease with tenants that was not due to expire until November, I think this was of 2021. And she had an illegal provision in her rental agreement that said, if the property is sold then I can give you a 60-day no cause notice. So that's illegal. Can't do that in a lease. Her realtor said, look, it says you can do that right there. Absolutely, you can do that. Did not encourage her to get legal advice. She served the notice. She sold the property or got an accepted offer, served the notice. Tenants didn't move out, went to court. She filed on her illegal notice, took it to the sheriff to serve, and decided to call me after she was driving away from the courthouse. And I'm like, oh, my dear. Oh, dear, you have a huge problem. I want you to turn right back around, go to the sheriff, try to retrieve those documents, get your money back if you can, go to the court, see if you can cancel the filing, although it's probably been accepted, but see if you can file a motion to dismiss. I want you to go back home. I want you to write the tenants a letter. I want you to email it to them and send them a copy in the mail, letting them know that the notice you served was served in error and has been officially rescinded. By the time she did all that, the tenants had lawyered up, and the tenant's attorney was demanding $20,000 to stop any court case. It's a huge problem, and that realtor gave her seller, legal advice, which is illegal for you to do. And you can actually be brought up before charges before the bar if you give illegal advice that you're not qualified to give. So it's beyond your expertise. Don't say yes or no. Say you need to speak with an attorney, a qualified, competent attorney. A property sale with tenants in place requires better advanced planning by sellers, more thorough investigation by buyers, and for realtors, it requires a higher level of due diligence than ever before. Acting as a fiduciary to your clients means educating yourselves to provide clients with the best information possible as to the benefits, drawbacks, and possible outcomes of selling tenant-occupied rental property. Thank you for your time. And before I start taking questions, I do want to make you aware there is my email address and my website address. On my website address, I have an article that I recently updated, and it is called Overcoming Barriers to Selling a Tenant-Occupied Property. It's so hard to explain all of these things to your clients. Well, my article will explain it for you. It's free to you to use. Go to my website, download it, email it to whoever you want. And hopefully that helps everybody involved with the transaction understand what they can and can't do and calls out a lot of what I've just talked about today. All right, I'm going to stop sharing now and we'll do questions, correct?
Correct.
Okay.
Wonderful information. Thank you, Tia. And we do have a few questions that have come in.
I went fast, so we'd have time.
Yes, well done. So the first, can you serve a 90-day notice to the tenant if you are going to market the property as is because it needs major renovation or to be demolished, or do you still not until you have an offer?
Well, like I said, you've got the two options. One is the renovation, but if your owner can't afford to do that, then that reason's gone away. You have to have an accepted offer from a buyer who intends to occupy it as their primary residence.
The next one, are the buyers allowed to receive, in addition to the rental agreement, the tenant's original application?
Usually not. I know property management companies will not release that to you. You can try to get some of the information off of it. I've seen some landlords offer new applications to tenants just to get that information. But interestingly enough, there's nothing in landlord-tenant law that says they have to fill that out once the tenancy is begun. They don't even have to sign your rental docs. In manufactured housing law, that's different. But and I would like to see it be a requirement in landlord-tenant law regularly. But they don't have to sign anything once the tenancy is begun, which when you inherit defective paperwork can be a huge problem for you. Now, I do have another article on my website called Taking Over Existing Renters. And one of the things I talk about in that article is how to cure a waiver that the prior landlord might have created. So even if the tenant doesn't agree to sign your paperwork, you can cure your waiver. And 90.262 does allow a landlord to change certain rules during a tenancy. Right? If it's, so there's certain things that you can implement if they haven't been implemented. So, that's a good article to check out too.
And would that be usually something that is cured in court or just via paperwork?
No, you just serve a notice of change in terms. But be careful, that statute says that any change that poses a substantial modification to the bargain is not enforceable unless the tenant consents in writing. So if they'll sign your new tenancy docs that say, hey, your late fee is this and these are your new rules, and most people will, in my experience, when I would take over management, probably 90% or more of people were nice people, they wanted to be cooperative, et cetera. And would sign, but there was always the special few who didn't. One guy ended up having to evict because he would never acknowledge that I was the landlord. He kept sending, our company was the manager now. He kept sending his rent to the old company and they kept returning it. It was like, I called him, I wrote him letters. It's like, come on, dude, we're your managers. And he was mentally ill and he refused to acknowledge that. So.
What happens if a tenant dies while your buyer is purchasing an investment property?
That's a great question. So death of a sole tenant is basically the ultimate act of abandonment. So it depends on whether there's more than one tenant as part of the process. If there's only the sole tenant, then you get possession back, because the landlords are allowed to take possession of a property if the tenant legally abandons the unit. So that's covered under ORS 90.147. And it basically, says the landlord reasonably believes under all the circumstances that the tenant has abandoned the unit and no longer intends to assert a right of possession. A dead person cannot assert a right of possession. So it's automatically considered abandoned. But if you have if there's more than one tenant there, then the tenancy just continues. There's nothing the landlord has to do. But you still are responsible for a deceased tenant's personal property. I think it's really important, and I talk about this in my classes, that it's important to have a death contact, because if you do, dealing with the deceased's personal property is going to be much easier than if you don't. So it's important to update that information periodically.
What is the best resource to keep up to date on tenant landlord laws in Oregon as they change? Besides you, obviously.
I would recommend that you join a rental owners association, either mine in Lane County. I'm the president of that. We'd love to have you. And if you let them know I referred you, I'll get $20 off my next renewal. Not that you but just throwing that out there for the heck of it. But we have chapters in almost every area. We have chapters in every area of the state and in many counties. You can go to the Oregon Rental Housing Association website to see what chapter might be close to you. And I'll tell you what, COVID changed everything. Almost all of our classes are online now, right? You can belong to a chapter anywhere in the state. You'll get, regular email updates from Oregon Rental Housing Association. So we have a legislative team. We tell you when laws are changing and what you need to know and be aware of. So many landlords did not plug in to the Rental Owners Association and ended up paying horrendous fees because they didn't know what they were doing and they had no idea that the laws had changed.
We have someone asking for clarification regarding if a new tenant is added to an existing lease, do the termination timelines reset?
They do. I bet the tenant advocates are going to be looking at that for the next year. I know that we're a little concerned legislatively that we may end up with a Democrat supermajority again. And if that happens, I think we can kiss no cause notices goodbye. But in regards to, what was the question again?
Well, we go back.
Oh, the tenancy reset.
Yes.
In regards to that, yes. So, sure, honey, crappy tenant, here, I'll let you add your even more crappy boyfriend. Sign here, please, sir. And you can get him out on a first-year basis. I was helping a landlord with evictions from these awful tenants in Lynn County. And I'm like, you need to go do an inspection. She did. And she found out that the tenant's husband, who was not a party to the original agreement, was living there. And I said, offer to add him. And she did, and he signed, and we sent him a 30-day no cause. And boy, was that tenant hopping mad because she didn't know that, right? So ignorance of the law is no excuse for us, and it's no excuse for them either. And we got her out. That was very satisfying because we had evicted her probably 3 or 4 times. She just kept not paying rent and then would come through at the last minute, and it's super frustrating.
We have a couple of questions regarding serving 90-day notice. So what do you consider the best way to serve a 90-day notice with an out-of-state seller?
First-class mail, and first-class mail, right? So every notice I serve is served by first-class mail. An out-of-state owner doesn't have the right to serve by post and mail anyway. You can try to personally serve, but I don't recommend it. Attorneys are always going to tell you serve by first-class mail. Now, One exception, I was in court the other day with an attorney who I was serving personally. We knew the defendant was going to be there. She had brought in rent. We were having to dismiss that case. We handed her 2 notices right then with both of us as witnesses, right? So our timing was better. But yeah, first-class mail is the way to go. But mail does get lost or stolen, right? Things do happen to mail. So I always recommend that you provide a courtesy copy of any notice, plus the addendum and all of that by email or text, or by posting a courtesy copy on the door. But don't let that make you check the box for post and mail. I've seen people do that. We had one of our own members lose a court case in Lane County because even though she mailed the notice and added the extra 4 days to account for mailing time, she checked the wrong box, right? It seems so easy, like I said, but there are so many little technical details, and a tenant attorney would be only too happy to educate you for an exorbitant fee.
For our Eugene clients with the 90-day notice in Eugene, does that include Springfield or just within the city limits?
No, Springfield's wonderful. Thank God for Springfield. Eugene, I wouldn't want to be a rental owner in Eugene. But like I say, and there's a lot of rules, but if you're a dedicated rental owner and you're holding a property for investment purposes and you screen well, and if you have good tenants and you follow the rules, it's still a great job to be a landlord, right? Problem is most people don't treat it like a business. They're lazy landlords, and COVID made them even more lazy. They don't inspect. And then they're like, oh my God, the tenants destroyed the property. And it's like, and who do you blame? The person you're looking at when you brush your teeth in the morning, because you're the one who let it happen. I don't know what it is about business owner. Most business owners realize their business is a business, but a lot of landlords don't treat it that way, and it comes at their detriment, and they pay a heavy price.
If a tenant agrees, can you use a text to give notice for showing?
Yes, if the tenant agrees in writing as part of 90.322, if agreed in writing, then a landlord can email or text their notice to enter. Yeah.
We have a couple of questions here about month-to-month terminations regarding how do tenant terminations work with month-to-month leases?
Well, a month-to-month rental agreement is a periodic agreement that rolls over every month, right? So until one party or the other gives legal notice. So again, in the first year, you can give a 30-day no-cause notice and don't have to pay them unless you're in Eugene, Milwaukee, or Portland, in which case you do have to give a 90-day notice, and you may have to pay them unless you're exempt. So each, Portland and Eugene have different rules for exemptions, different requirements for claiming exemptions, different forms that need to be served. It's very complicated. You can go on to the Portland Housing Bureau website and check that out, or the Eugene Rental Housing Code website. They just finished getting the city manager's interpretive rules, and I'm working on an article about it right now. I will have it hopefully done for inclusion in the June newsletter for ROA, and I will publish it statewide through the Oregon Rental Housing Association as well. There's still a few things that we're asking questions about, like the 2-unit owner-occupied exemption that they didn't really address. Interestingly enough, there's a 3 strikes option in a fixed-term lease. In Portland, you still have to pay them relo if you do a 3 strikes non-renewal. In Eugene, you don't. So the rules are different, ever so slightly different in each area.
If a trailer is in a park on a month-to-month lease, are the rules the same as a single-family residence?
No. Manufactured housing law or park rules are different unless it's an RV park. So RV parks are, strictly for recreational vehicles, right? The thing isn't on a foundation. So no, those rules are extremely different. And I'm not super up on those. Usually if somebody calls me, I can look through and we can find the information they want, but that's not my specialty. There is an Oregon Manufactured Housing Association group that helps people with that, teaches classes and things. But if it's an RV, not in a park, then the same rules apply as for single family, regular residential tenancy, except that if you're going to you can give a no cause notice even after the first year, but it's a 180-day notice for no cause. So each situation is a little different. Yeah.
Would you suggest for a buyer's agent to write in the offer when requesting seller to give notice that you would require the seller to use a specific company to use to serve notice?
Sure, somebody you can trust. I think talking about that's really important, because I've seen these just go south and poor buyers end up going, what the heck? I think it's really important. Have an attorney do it, have an eviction specialist do it, have me do it. I'll charge you $85.
That was one of the other questions, is how much you charge, so that's perfect. $85, okay. What if the seller plans to tear the house down and sell the bare land because it's beyond repair? Can you serve a 90-day notice without an offer in that circumstance?
Yes, you can. Absolutely. So that's one of the qualifying landlord reasons you're going to demolish the unit or convert it to a different use, right? So Eugene just doesn't have enough marijuana shops. We need one more and my property's zoned correctly. So I'm going to change it to a marijuana shop or a vacation rental. But beware of that. A lot of people confuse short-term furnished rentals with vacation rentals. There is a specific definition in landlord tenant law. Vacation occupancy means occupancy in a unit for vacation purposes only, not as a primary residence. The occupant has a primary residence other than at the dwelling unit, and the period of authorized occupancy does not exceed 45 days. In Eugene, same rules, except it's 30 days. So, people who are doing the furnished finders, traveling nurse thing, that's a residential tenancy. That is not vacation occupancy. They are occupying it as their primary residence during the time they're there. So transitioning from regular rental to furnished finders, there's no transition there. It's the same thing. It's only a shorter term tenancy for a higher rent amount.
If you purchase a home or duplex that is far under rented, can you reset the rent to value when the current tenants move out?
It depends on how they were terminated. That's a great question. So yes, you can set rent to market if you're terminating for cause, for one of 4 qualifying landlord reasons, or if the tenant gives you notice. But if you're terminating for no cause in the first year or the reset first year of occupancy, you're only allowed to raise rent for the next tenant by whatever you could have raised rent for the tenant you just terminated, right? So if you terminate a tenant in the first year and they've been there 6 months, you've got to offer the property at the same price they were renting it for.
This one's a pretty specific question. How can you move forward with tenants that never signed any paperwork? So for example, an elderly owner just agreed to let them move in, but it's been less than 1 year. What happens if they end up living there over 12 months?
Over a year, then they've got more rights than if they're there less than a year. And while that's not a great idea, there's still a lot in landlord tenant law that that the tenants must abide by. My favorite section of landlord tenant law is the tenant duty section. And it says the tenant shall use the premises, including the living room, kitchen, bedroom, bathroom, and dining room in a reasonable manner, considering the purposes for which it was designed and intended. Keep all areas of the premises under control of the tenant, and every part is clean, sanitary, and free from all accumulations of debris, filth, rubbish, garbage, rodents, and vermin, as the condition of the premises permits, and to the extent that the tenant is responsible for causing the problem. They must cooperate to a reasonable extent in assisting the landlord in any reasonable effort to remedy the problem. They have to properly dispose of their trash. They must use in a reasonable manner all electrical, plumbing, sanitary, heating, ventilating, and other appliances in the premises. They must behave and require other persons on the premises with the consent of the tenant to behave in a manner that will not disturb the peaceful enjoyment of neighbors. They can't tamper with smoke alarms, and they cannot deliberately or negligently destroy, deface, damage, impair, or remove any part of the premises, or knowingly permit any person to do so. So I did a 4-cause notice once. The landlord went in and the carpet in the entire unit was gone. Carpet and pad is gone. All of the subfloors were covered with tarps. They had dogs, and we assumed that the dogs destroyed it. So that's great. Here's your 4-cause notice. You've got 14 days to replace all the carpet and pad with comparable carpet and pad. They took one look at that and moved out. So, they couldn't cure. They didn't have the money to pay for it, but they removed it. And he only had a verbal agreement, but they removed part of the premises. And so, yeah, there's lots of little ways that you can enforce the terms of the rental agreement. Or landlord.
With month-to-month leases, do the cause, no cause laws still apply? That seems to be a common theme.
Say that again.
With month-to-month, do the cause and no cause laws still apply?
Sure. And leases, they apply too. You can always terminate a lease early for cause, right? It's just you can't terminate it early for any other reason, including 3 strikes, right? You aren't required to continue it after that.
Well, it looks like that's the end of the questions that have come in. Tia, amazing information. Thank you so much. We're getting a lot of thank yous in the chat as well about great information, and they're sending clients your way. For all of our realtor partners, thank you for being here. We'll be sending out those CE certificates as well as Tia's information, so you can contact her for your clients, her slide decks, and all of that information. So look for that by the end of the week. Thank you for being here.
Yeah, thank you.